Many of you have heard me say this before. Trademark rights are based on use of the mark. So does that mean if you're not using a particular mark that you can't file a trademark application for it? No, it does not mean that. The United States Trademark Office has a type of trademark application called an intent to use trademark application. As the name implies, you must have a bona fide intent to use that mark in order to file this type of application, but you do not have to actually be using it. And we do recommend this approach in many cases, but there's a few things you need to understand. One thing is, it is going to likely cost more to do an intent to use trademark application than a trademark application based on actual use. The reason for this is there is a secondary filing that we must do down the road once you have started using the mark. The good news is that additional cost is not collected up front. It's actually more likely to be a year or more down the road. Another piece of good news about intent to use trademark applications is it gets the lengthy trademark application process started. It gets your information into the United States Trademark Database so that other people who may be considering filing for an identical or confusingly similar mark to yours will see your application in there and have to consider that as part of their approach. So there's good news and bad news when it comes to intent to use trademark applications. But if you have a mark that you want to protect and you expect that you'll be using it within the next, say, 12 to 24 months, we typically recommend an intent to use trademark application as a good strategy.